Yes, get ready for the non-stop dictation at the speed of 90 words per minute. 5, 4, 3, 2, 1, start. Question of securing obedience to its orders any further does not arise. The Learned Council also submitted that enforcing the interim order after it is found that the court had no jurisdiction to try the said suit would not only be unjust and illegal but would also reflect adversely upon the dignity and authority of the court. It is also suggested that the plaintiff had instituted the present suit in the civil court knowing fully well that it had no jurisdiction to try it. It is not possible to agree with any of these submissions not only on principle but also in the light of the specific provision contained in Section 9A of the Code of Civil Procedure Maharashtra Amendment. In the light of the said provision, it would not be right to say that the civil court had no jurisdiction to pass interim orders or interim injunction, as the case may be pending decision on the question of jurisdiction. The orders made were within the jurisdiction of the court, and once this is so, they have to be obeyed and implemented. It is not as if the defendants are being sought to be punished for violations committed after the decision of the High Court on the question of jurisdiction of civil court. Here, the defendants are sought to be punished for the disobedience and violation of the order of injunction committed before the decision of the High Court in Land Acquisition Officer versus AIR 1996 Bombay 366. According to Section 9A, the Civil Court and the High Court did have the power to pass interim orders until that decision. If they had that power, they must also have the power to enforce them. In the light of the said provision, it cannot also be held that those orders could be enforced only till the said decision, but not thereafter. The said decision does not render them the interim orders passed meanwhile either non est or without jurisdiction, punishing the defendants for violation of the said orders committed before the said decision. Vishanji does not amount, if any, event to enforcing them after the said decision. Only the orders are being passed now. The violations are those committed before the said decision. The correct principle, therefore, is the one recognized and reiterated in Section 9A, to wit, where an objection to jurisdiction of a civil court is raised, to entertain a suit and to pass any interim orders therein, the court should decide the question of jurisdiction in the first instance, but that does not mean that pending the decision on the question of jurisdiction, the court has no jurisdiction to pass interim orders, as may be called for in the facts and circumstances of the case, a mere objection to jurisdiction does not instantly disable the court from passing any interim orders. It can yet pass appropriate orders. At the same time, it should also decide the question of jurisdiction at the earliest possible time. The interim orders so passed are orders within jurisdiction when passed any effective till the courts decides that it has no jurisdiction to entertain the suit. These interim orders undoubtedly come to an end with the decision that this court had no jurisdiction. It is to open the court to modify these orders while holding that it has no jurisdiction to try the suit. Indeed, in certain situations, it would be its duty to modify such orders or make appropriate directions. For example, take a case where a party has been dispossessed from the suit property by appointing a receiver or otherwise. In such a case, the court should, while holding that it has no jurisdiction to entertain the suit, but back the party in the position he was on the date of suit. But this power or obligation has nothing to do with the proposition that while in force these orders have to be obeyed and their violation can be punished even after the question of jurisdiction is decided against the plaintiff, provided the violation is committed before the decision of the court on the question of jurisdiction. That judgment did not deal with the effect and impact of interim order on the transactions made while the interim order was in force, though it has been held that it would be amount to breach of interim orders. Over.